Firstly, just because the room might be suitable for use as a separate dwelling, doesn't, we say, preclude the shared house from being suitable for use as a separate dwelling. So maybe that both of us come in line as a definition. And secondly, in relation to the 2012 order, our case is that the 2012 order doesn't apply to make the accommodation unsuitable because the basis upon which the accommodation is held doesn't come within the ambit of the order.
In this case?
In this case. So I will pass over to my own friend.
My lords, I'm going to deal with ground 3 first, because that will give me an opportunity to explain to you the mechanism of the Act and how one approaches it. Before I do that, we've handed in a small clip of additional further authorities. Behind divider 1 is section 146 of the Housing Act 1980, which deals with houses in multiple occupation overcrowding. Behind tab 2 is section 358 of the 85 Act. Behind tab 3 is extracts from the 2004 Act, section 67, and after section 67, schedule 4, paras 1 and 1A. They deal with the provisions, the conditions that must be included in an HMO licence. And paragraph 1A, which starts on the penultimate page of that tab, deals with levels or densities of occupation. And you might notice that although there's been an upgrade to square metres, which may or now, following Brexit, be under challenge, of course, under threat, they are identical areas to those that are contained in the tables in relation to overcrowding under the 85 Act.
How many square feet is a square metre?
Well, it's a little bit more than there's 3.3 something feet in a metre, and it's a little bit more than 1, so you divide by 10 effectively, and a little bit. So 6.51 square metres is 70 square feet.
Thank you.
10.22 square metres is 110 square feet. And 4.64 metres is 50 square feet. And then behind divider 4 is the 1996 order, suitability of accommodation order. Which my Lord Nugee stated was made under the...
It was actually...
Oh, sorry, my Lord Stuart-Smith, I apologise. Stated was made under sections 1773 under the powers under 2110 subsection 2b of the 1996 Act, about which he's absolutely right if you look in the preamble. And it's rather embarrassing for me because I was arguing about this very recently in a case called Bapty. Trying to remember the borough now. And the London Borough, in which judgment was recently handed down.
Yes, indeed.
Well, I'm always glad to give assistance, Mr. Finley.
I'm very grateful.
But I think it does provide a rational explanation as to why the 96 order refers to reasonableness and suitability, and the other two refer to suitability.
So, in fact, in my submission, it's going to support my case because it indicates that where Parliament is intending to make a distinction between suitability and affordability, it does so, and where it's intending to include both of them, it does so. What the 1996 order concerns is affordability. And accommodation is neither reasonable to continue to occupy or suitable if somebody cannot afford to pay their rent, having met their basic essential needs on their other basic living costs. So under the 1996 Housing Act Part 7, people are entitled to make a homelessness application to the local housing authority. The local housing authority accepts the application and then has to decide a number of factors. And those are whether or not the person is eligible for assistance, whether or not they are homeless or threatened with homelessness, whether or not they have priority need, and whether or not their homelessness is was intentional, or they are intentionally homeless. It's not suggested that they intended to make themselves homeless. There are provisions as to how you become intentionally homeless. The criteria that somebody satisfies or is found by the local authority to satisfy determines what duty is owed to them. So the main housing duty, the Section 193 duty, is owed to people who are homeless, well, eligible for assistance, I apologise, homeless, other than intentionally homeless, and have a priority need. And the Section 193 duty is to secure that accommodation is available for that person until the duty ceases. And the duty can be brought to an end in a number of different ways. When the 1996 Act was originally enacted, the principal way in which the duty under Section 193 ended was by an offer of a social housing tenancy. So it's either a council tenancy or a tenancy from a housing association to which the local authority had rights of nomination. That relationship has been decimated over the years, and now the Section 193 duty can be ended by what's called a private rented sector offer. And that's an offer effectively of an assured tenancy for a term of more than 1 year from a private landlord. Whilst the local authority is carrying out its inquiries as to what duty, if any, it owes an applicant, it may have an interim duty to house a person. So where there is reasonable cause to believe that that person is somebody who has priority need, the local authority will have a duty to house them until it makes its initial decision. Where the local authority makes an initial decision that is adverse to the applicant's interests, so it finds, for example, that they don't have a priority need, or as in this case, that they are not homeless, the local authority then has a power to provide them with accommodation. So not a duty, but a power. Whenever the local authority has a power or a duty to provide accommodation, that accommodation must be suitable. Somebody who is dissatisfied with the initial decision that has been made on their application has the right to request a review. And that's what happened in this case. So if we go to the initial decision, that's in the core bundle, my lords, at tab 10, page 107. The paginating is quite difficult to see because it's in the black bit of the heading of the letter. And you'll see there at the bullet point that the initial officer considering the case found that Miss Rowe was not homeless or threatened with homelessness because she had accommodation available for her at 28 Collis Road, the property that we now know as an unlicensed HMO, which is reasonable for you to continue to occupy. And you'll see there at the third paragraph down, in considering your homeless application, I consider the question as to whether your accommodation at 28 Collis Road, etc. is available for you and whether it's reasonable for you to continue to occupy. In deciding the two important points above, I have taken into account your representations, the Homelessness Code of Guidance. And then some facts are set out. Over the page at page 108, under the heading, my lords, reasonable to continue to occupy 28 Collis Road, London, Haringey, N154NR. You'll see the last bullet point, the first bullet point says, you currently occupy a room in a shared house which is of suitable size for you, your 7 and 4-year-old boys. You are not overcrowded. It is reasonable for you and presumably your household under the space standards set out in the Housing Act 1985 And then it sets out the reason. And then the last bullet point says, you advise that you do not feel comfortable because, one, a tenant at the property reported to the landlord that your children keep running around. You confirm that although you feel uncomfortable, you do not feel at risk in your home. And that letter has to notify the applicant of their right to review. I've handed in my two copies of the letter at tab 14 in the supplemental bundle, which was unfortunately left out, that bundle. So I've got my Learned Junior's electronic copy, Oh to be thoroughly modern. So an applicant who requests a review is given an opportunity to make representations. And in this case, Miss Rowe instructed Law Stop solicitors who made representations on her behalf. And I would just ask you to read through those representations because they set the parameters for what the reviewing officer must consider on the review. So that was the letter that was handed in, two copies of it. And if I could just ask you to look through that and see what it is that was raised by Miss Rowe on her representations. You'll see there that there's no reference to overcrowding of her room or indeed of the house as a whole.
Well, it does say at the end of the third bullet point the children don't want to be in the room because of the lack of space.
It does.
It's not statutory overcrowding, but it is a complaint that we don't have enough space.
Yes. So that's what the reviewing officer was responding to. You've been taken to the review decision. It is shorter than many review decisions you might see in this. Thank you. It is shorter than many of the review decisions that I've seen in this area, but because the number of issues that were raised were possibly fewer than in many other cases. My own friend has taken you to paragraphs 11 and 12 of that. That's behind divider 9 in the core bundle, my lord. And I just ask you to read paragraph 13 as well, and paragraph 10. Not necessarily in that order.
And in the first line of 13, it should again be because once a tenant, shouldn't it?
Yes.
Does seem to have copied the grammatical errors from the decision below.
Not all of them.
Well,
But
there's not only that one in the first line of
Yeah.
13, but there's also the one in the second sentence of paragraph 11. It is reasonable for you and household occupy.
Yes.
That does suggest perhaps not a very careful, fresh look at the issues.
Yes. So my learned friend has conceded, I think, that the issues that the review officer has to consider are those that are raised by the applicant, and I would accept that, unless they are things that no reasonable authority properly directing itself would have failed to otherwise consider.
Or to inquire into.
Or to inquire into.
Does that include the whether
So
an HMO is licensed or not?
So my client received advice after this appeal was lodged that it is at least strongly arguable that once given that the local authorities have the obligation to manage the licensing of HMO regimes and the inquiry wouldn't be very difficult, probably
Consulting their own register.
Marking their own homework, it probably wouldn't be very difficult. And given that the purpose of the HMO legislation is to ensure that HMOs are safe, that might be something that your lordships would have taken the view that no reasonable authority properly directing itself would have failed to inquire into. Now, it's my submission that specific point, the failure to make inquiries, is not something that's raised by this appeal. It was raised below by my learned friends junior, but it doesn't form one of the grounds of this appeal. Because the point out, if it's a failure to make inquiries, the local authority can now go back and remake its decision. And it can go and have a look at the HMO and see whether or not it is as my Lord Stuart-Smith said, if it's a fantastic HMO other than a failure to be licensed. So notwithstanding that it is an unlicensed HMO, it's our position that that doesn't make it unreasonable to continue to occupy.
What do you mean is it doesn't by itself make
Of
it
itself, but but the fact that it is an HMO and it is unlicensed raises further inquiries, which probably require an inspection. But that isn't the way the ground is put, that isn't the way the unlicensed HMO point is put by my learned friend. Although if you look at the first instance grounds, which are behind dividers tab 6, at page 74, you'll see that ground 3 at the bottom of that page was failure to take into account relevant considerations, and in taking into account irrelevant considerations, the review decision failed to take into account relevant consideration into whether the property is an HMO which appears to be unlicensed. And if you turn over the page to page 76, ground 7, failure to make inquiries, at page 77 you'll see that ground, which appears to contain 5 grounds, there was a failure to make inquiries as to whether the property was an HMO which required a licence. So that's the very clear terms in which it was put below. But not pursued here.
Yes, well, of course, in formulating their grounds for the appeal to this court, the appellant's representatives would have had to have borne in mind the requirement to raise grounds that have raise an important point of principle or practice.
I accept that.
And it might be debatable whether an isolated point about making inquiries satisfied that criterion.
My lord, yes. So that explains the process in the whole and how it played out in this case. The point at which whether or not accommodation is suitable for somebody to continue to reasonable for somebody to continue to occupy has to be considered is the point at which it is being considered whether or not they are homeless. And that's section 175, subsection 3. There is no reference in section 175 or the other sections that deal with whether or not accommodation is reasonable for someone to continue to occupation, such as section 177 that deals with domestic violence, etc., of suitability. There is no reference to suitability at all. The word suitable is not used. The point at which a local authority has to consider suitability is when it is securing that accommodation is available for somebody to whom it owes a duty or is exercising a power is being provided with accommodation by that local authority. If Parliament had intended that the same test apply at both points, it could have used the same word. So in the in the case of Tema and Hackney London Borough Council, which is a 2015 and is at divider 19 in your bundle, and you'll note post-dates the decision in Alley. The issue was whether or not a review decision was unlawful for public law in public law terms, because the review officer had failed to consider whether or not the accommodation in which Miss Tema was residing suffered from any health and safety hazards under Part 1 of the Housing Act 2004.
How many?
4.
Okay.
So the 2004 Act introduced a new system of considering whether or not accommodation was safe, and effectively it's a hazard system. The argument that was put on behalf of Miss Tema was that because there had been a failure to consider whether or not there are any hazards, which would have made the accommodation unsuitable if it was being offered by the local authority, it was also unreasonable for her to continue to occupy. Lord Justice Jackson, at paragraphs 47 to 56, rejected that submission in pretty trenchant terms. Sections 175 subsection 3, 176, 177 subsection 2 of the 1996 Act set out the test to be applied to the stage 1 exercise. The stage 1 exercise being whether or not it's reasonable for somebody to continue to occupy their accommodation. Essentially, the local authority must consider whether the existing accommodation is such that it would be reasonable for the applicant and anyone living with her to continue to reside there. In carrying out this exercise, it can have regard to the general circumstances prevailing in its district. Sections 206(1) and 210 as amended of the 1996 Act set out the test to be applied in the stage 2 exercise. This is a more elaborate test because it may involve carrying out a hazard assessment under the 2004 Act. I won't read paragraph 49. Paragraph 50. Mr. Colville submits that we should construe the statutory provision so that the stage 1 exercise and the stage 2 exercise involve applying the same standards. In other words, when considering whether it is reasonable under section 1753 of the 1996 Act for someone to continue to occupy accommodation, the local authority must consider whether that accommodation is suitable within section 206(1) of the 1996 Act. That in turn will or may involve carrying out a hazard assessment under the 2004 Act. In support of this submission, Mr. Colville, like my learned friend in this case, relies on RV Aways. That's a different name for the Alley case. This well-known homeless at home decision arises out of large numbers of homeless applicants in Birmingham and the chronic shortage of housing accommodation in that city. I will read the rest of that paragraph. Paragraph 52. I therefore conclude that Aways case does not support the applicant's case. On the contrary, it supports the local authority submission that stage 1 exercise and the stage 2 exercise involve applying different standards. When I stand back and look at the provisions of the statute, I can see that Parliament has established different sets of rules for the stage 1 exercise and the stage 2 exercise. There would be no point in doing this if the intention was that both exercises would assess accommodation in the same way. So, in my submission, Timmer is binding authority on this court but the stage 1 exercise and the stage 2 exercise are different. And a failure to decide whether to determine whether or not any accommodation is suitable under section 206 and the subordinate legislation brought into being under that section does not impugn a decision as to whether or not some accommodation is reasonable for a person's continued occupation. As I understand it, my learned friend is bravely submitting that in fact the suitability test is lower than the reasonable to continue to occupy test. In my submission, that would give rise to the situation described by Lord Justice Ward in Haringey, tab 15, as ludicrous. I will explain. So the local authority has found that somebody is homeless, so they owe them the section 193 duty. Their obligation is only to provide them with accommodation that is suitable, which is a lower standard than, on my learned friend's submissions, the one of reasonable to continue to occupy. So they put them in some suitable accommodation. But that suitable accommodation, although it satisfies the suitable to occupy threshold, doesn't satisfy the reasonable to continue to occupy threshold. So as soon as the local authority puts them in that accommodation, they are homeless again, immediately.
That's what happens in Ali, isn't it?
No, it isn't. I'll come to Ali. I'll explain the rationale of Ali in a moment. But if I could just take to paragraph 20 of Lord Justice Ward's decision, or the decision of Lord Justice Ward in the Haringey case, which is on page 150 at tab 15, my lord. Bless you. So at paragraph 20, Lord Justice Ward says this: there are various ways to test that conclusion. That conclusion for these purposes being whether or not the code of guidance, which said that that it would be reasonable for somebody to continue to occupy overcrowded accommodation, was correct. Because you'll see in the paragraph immediately preceding paragraph, Lord Justice Ward has said that he was satisfied that the code of guidance correctly expresses the law. For these purposes, the code of guidance is set out, or the code of guidance that was then enforced is set out at paragraph 5 on page 146. And paragraph 8.27 says paragraph 8.28 effectively says that overcrowded accommodation may nonetheless be reasonable for somebody to continue to occupy. In Haringey, what was happening was that it was being suggested that it could never be reasonable for somebody to occupy accommodation if that meant that they were committing a criminal offence. And you've discussed the overcrowding criminal offences with my learned friend. So what Miss Bretherton on behalf of, can't remember whether it's Mr. Haringey or Miss Haringey, on behalf of Haringey was submitting was, if accommodation is overcrowded, that gives rise to a criminal offence, and it can't be reasonable for somebody to continue to occupy accommodation on the basis of commission of a criminal offence.
I think you're in fact addressing a submission which was opposite to the one that Mr. Van Heegen was intending to make. It's quite true he used the words lower test, but what I understood him to mean by that was lower in that it would be easier for the appellant or the applicant, as the case may be, to meet. In other words, easier for the applicant to show that accommodation would be unsuitable than for her to show that it would be otherwise would be reasonable for her to occupy. I think that's what he meant. In those circumstances, the ludicrous result wouldn't follow, although there might be other problems.
Well, my lord, I mean, I think you're being very generous to my learned friend. It seems to me to be pretty clear from his skeleton argument that his submission is that Ali must be authority for the proposition that because the accommodation in Ali must have been suitable, because the local authority had placed Mr. Ali in that accommodation, but it wasn't reasonable for him to continue to occupy, the test for suitability is a lower test than the test for reasonable to continue to occupy.
You mean a lower standard?
A lower standard.
Yes,
Yeah.
I think lower standard is perhaps a clearer way of putting
Yeah.
it.
Easier to overleap.
Yeah.
It is easier for the local authority to find suitable accommodation than it is for them to find accommodation that it's reasonable for someone to continue to occupy.
Yeah.
And that does give rise to the ludicrous position that Lord Justice Ward describes in Haruki.
But is that necessary? So, I mean, because all these statements have to be viewed in their factual context. I mean, if it's one and the same accommodation, then you can understand the point being made. But what if it's different accommodation?
So they've moved from their accommodation that it wasn't reasonable for them to continue to occupy because the local authority has found that. It said we have the duty to you, and it's provided them with suitable accommodation. Is that your question?
Hmm.
Well, in those circumstances, that accommodation may be both suitable and reasonable for them to continue to occupy.
Yeah.
But on my learned friend's submission, it could be that it's suitable, but because the reasonable to continue to occupy standard is a higher standard, it might not be reasonable for them to continue to occupy.
So although you've discharged your duty under section 193, the very
Yes.
next day
They're
you're
homeless.
homeless again.
Absolutely.
So
then you can put them
it's-
back in the
circle works the opposite way round.
Yes.
Yeah.
And that's exactly the circumstance that Lord Justice Ward says. I can't construe suitability as a lower standard than reasonable to continue to occupy, because that would just result in this revolving door.
Well, I understand the submission you're making, but how does that assist us? Because does that not tend to confirm that Lord Justice Ward was correct to say that they're related concepts? You've been making the point that, as indeed Mr. Van Heegen accepted, the tests arise at different stages, which in Timor is referred to as stage 1 and stage 2. But you run into problems if you apply a different threshold or standard under either test.
With respect, my lord, you don't. Lord Justice Ward's conclusion in that respect is not dependent upon the two concepts being related at all. It's dependent upon suitability being a lower standard than reasonable to continue to occupy. That's all. And with respect, my lord, if they were intended to be related concepts, Parliament could have used the same words. Now, it is absolutely right that there are parts of them that are analogous to one another. So, for example, both of them have to be considered over a period of time, so that something that is reasonable to continue to occupy for a short period of time may not be reasonable to continue to occupy for a long period of time. And that's the effect of the decision in Ali. Likewise, something that is suitable for a short period of time may not be suitable for a longer period of time. But in my submission, there are very good public policy reasons why the suitability test should be higher than the reasonable to continue to occupy test. A higher standard. I apologise, not test. The standard under suitability should be a higher standard than the standard under reasonable to continue to occupy. Because in relation to the suitability, what we have is the state, through its agency of local authorities, securing accommodation for people. And on the whole, once the Section 193 duty has arisen, we know that those people are in priority need. So in generalisation, they have some vulnerability. They may have young children, they may be ill, or they may be elderly.
Yes, so your point, putting it in my own words, is that because it's the authority providing accommodation in discharge of a duty or power that it has, at that point, the local authority is in control and can determine what happens. So to take the example given by my Lord Justice Nugee this morning, if it's a matter of a written tenancy agreement, it's a very simple matter for the local authority to say to any private provider, if you want to provide accommodation, you've got to
Give us a copy first.
You've got to provide written tenancy agreements.
Absolutely.
Whereas if you're considering reasonableness of accommodation for homelessness, the absence of such a written agreement may be of far less weight.
Absolutely.
That's your point, as I understand it.
Yes.
Right.
But
So, is this right? Your submission is there can be accommodation which would not count as suitable if at the stage 2, discharging the Section 193 duty, but it can still be reasonable to occupy when discharging the stage 1 inquiry whether someone is homeless.
yes. So
But I think we see from Ali that the converse can also be true, that someone can be homeless in the sense that it's not reasonable for them to continue to occupy their current accommodation, possibly indefinitely, possibly for a period, but it can still be suitable for them to do so in the short term.
So the point about Ali is that it isn't the House of Lords. The House of Lords was giving Birmingham City Council the ability to use its people's current accommodation to discharge its Section 193 duty, because that accommodation had not become accommodation that it was unreasonable for them to continue to occupy immediately.
But what they say, if I've understood it correctly, what Lady Hale says is you don't, when asking the stage 1 question, are you homeless, simply look as to whether you have somewhere to sleep that night.
No,
You look to the future,
you do.
because it's a question of whether it's reasonable to continue to occupy.
Absolutely.
And it may be reasonable for you to stay there another night, but not reasonable to...
Yes. In which case you satisfy the definition of homelessness.
So
And once you satisfy the definition of homelessness, the local authority has a duty to start looking for accommodation for you. But if you don't satisfy the definition of homelessness, your application is binned.
Well, I understand that.
But somebody can still be suitable.
But somebody like
In the short term.
Mr. Ali
But both, sorry, I apologise. Yeah. Sorry, my lord.
was homeless. I mean, that's the decision right at the end of the judgment. She was homeless,
Yes.
but it was still suitable on a temporary basis to leave the family where it was.
And it was reasonable for them to continue to occupy it on a temporary basis.
But then they wouldn't have been homeless.
They are, because that's what the decision is. The decision is, in order to be homeless, you have to look...
To a long term.
Absolutely.
So that accommodation was both accommodation, which it was not reasonable for them to continue to occupy for reasonableness purposes, but was suitable for them in the short term.
Well, perhaps if I could take you to El Kundi, because that, in my submission, explains or rationalises how one should, or the ratio...
Before you go there,
My lord, yes.
am I right in thinking Ali introduces the notion, it does away with the notion that the question of reasonableness and suitability has to be determined by reference to tonight.
It deals away with the presumption that reasonable to continue to occupy has to be dealt with tonight.
Yes. And the conclusion you can have a accommodation which it's although it's reasonable for you to continue to occupy in the short term or medium term.
Yep.
You're still homeless because looking to the future, it's not a permanent solution.
Absolutely.
And it's in that same context that certainly if the accommodation is being provided by the local authority, you may, having decided that they're homeless, albeit they can stay, accommodation is reasonable in the short term,
Yes.
you may come to the conclusion that it's suitable in the short term,
Absolutely.
but not in the long term.
Absolutely.
In which case, you've got to find other accommodation.
Absolutely.
Yeah.
So in my submission, the decision in Ali is a very practical one, because what it does is it prevents people of whom it is said, you've made a homelessness application, but you can carry on living there for another night, so you're not homeless yet. It stops them, their homelessness application at that point being resolved. It stops them then from having to, the next day, having to make another homelessness application.
Yeah,
And local authority
but
considering whether
doing it on a night-by-night basis would
Absolutely.
be utterly impractical.
Yes. And it allows the local authority then to start looking for what would be suitable long-term accommodation.
But does that mean leaving them in the suitable accommodation in the short term does not discharge your Section 193 duty?
It meets it, but it doesn't cause it to cease.
Yes.
Because in order to be caused to be ceased, the offer of accommodation has to be one that's going to be suitable in the long term, and not one that is suitable. In the short term. So what happens is somebody is found to be owed the Section 193 duty, and that is met immediately and temporarily, possibly by a series of temporary accommodations, whilst the local authority looks at the housing needs of the person, whether or not they can make them an offer in Solihull, whether or not it's a private rent, they can do discharged by private rented sector offer, etc., etc. And in Ali, that process of meeting the Section 193 duty by a series of temporary accommodation is held to be lawful.
And you can do it by leaving them where they are.
And you can do it by leaving them where they are.
Even though it's not reasonable for them to continue to occupy it in the long term.
In the long term.
And that it's reasonable to leave them where they are for the time being, because you've decided that although it's not reasonable for them to stay in the long term, it is reasonable for them to stay in the short term.
Yes. But what that does is that triggers the Section 193 duty, because you've found it's not reasonable for them to continue to occupy in the long term. You now have the Section 193 duty, and Baroness Hale's expectation is that then the local authorities will start trying to find the accommodation that will either meet for a longer period of time the Section 193 duty, or cause it to come to an end because it's a permanent offer of accommodation.
So you're really avoiding the replication of the sort of street homeless thing of whizzing off to the court on a Thursday afternoon and saying, give me accommodation this evening.
Absolutely. I mean, it all arose as a result of Birmingham, the massive pressure for accommodation in Birmingham, and Birmingham City Council's policy of saying, yes, we accept you're homeless, we can't do anything better at the moment, we'll have a look, but for the time being, you've got to stay where you are. And effectively, Birmingham City Council won the appeal. The appeal was, they won, and their policy was approved.
Well, except they wanted to leave people in where they were until they could provide accommodation, and Baroness Hale said, you can't do that.
Yeah, she said there will come a point where it is not reasonable for them to continue to occupy it for another night, and at that point they're entitled to an injunction. But on the facts in the case, the court didn't make an injunction in relation to any of the individual cases.
Can I just see if I've got this right? The important thing is, if it's not reasonable in the long term, the person is homeless, and the question arises how to meet the duty, the Section 193 duty. In deciding that, the existing housing may be suitable in the short term, or the council has to go out and find other suitable short stroke, ultimately long-term
That's right.
accommodation. And that's it.
Well, that's it.
Well, let me just write the rest of it down before I forget it. Please. you.
My lord, so the issue in El Kundi was the next issue after that, after what was decided in Ali. And the question was, when does the Section 193 duty arise? Does a local authority have a period of time in which to find that suitable accommodation, or once it's found that it owes somebody the Section 193 duty, does that duty arise immediately? And the applicants relied upon the Ali decision, and Lord Justice Lewis, giving the decision of the court, analysed Ali, I think from about paragraph 80. Sorry, apologise. It's 89, his analysis of Ali starts, which is on page 369, my lords. And he deals both with the Court of Appeal decision and the House of Lords decision. Paragraph 98, my lords, he sets out paragraphs 41 and 42 of Baroness Hale's judgment. And at paragraph 99 he sets out paragraphs 46, I think, to 48. No, further, I apologise, to 51 of Baroness Hale's decision. Paragraph 101 of Lord Justice Lewis's decision, he says this: analysing the speech, the basis for Baroness Hale's decision for allowing the appeal is that a person may be homeless for the purposes of Section 175 of the 1996 Act if he's in accommodation which it is reasonable for him to occupy at present, albeit that at some stage in the future it would cease to be reasonable for him to occupy. Given that a local housing authority would not necessarily be in breach of Section 1932 of the 1996 Act by leaving a person who is homeless in his present accommodation. Given that, I apologise, a local housing authority would not necessarily be in breach of Section 1932 of the 1996 Act by leaving a person who is homeless in his present accommodation. The reason is that it may become unreasonable for him to continue to occupy that accommodation in the medium or longer term, but it is not necessarily unreasonable for him to continue to occupy the accommodation at present. A local housing authority would not therefore necessarily be in breach of Section 1932 by leaving a person in his present accommodation, as the accommodation may be suitable in the short term. So, effectively making the same point, my lords, that Lord Justice Stuart-Smith just made. That, in my judgment, is the ratio decidendi of the decision. That is the issue that Baroness Hale, with whom the other members of the House agreed, decided in order to dispose of the appeal. Strictly, Baroness Hale did not reach a decision on the separate question of whether once it is unreasonable for a person to continue to occupy his current accommodation, the duty in Section 1932 is to secure suitable accommodation immediately, or whether the duty is to secure accommodation within a reasonable time.
Well, I think the answer you would give in the light of our previous exchange, is that once it becomes unreasonable for the person to stay in that accommodation any longer, there is an immediate obligation to secure suitable accommodation in its place.
And that was the effect of the decision in El Kundi. Yeah. You can't. So the question was, do we have a bit of time to sort of bumble around and have a look? And the answer was no. It's an immediate duty, but it may be that a court would not make a mandatory order immediately. My lords, in my submission that deals with the first way in which I think the argument is put, although it was slightly a movable set of foundations as far as I could see. Is suitability is it necessary, or must a local authority consider the suitability requirements even if they are not, even if a breach of the suitability requirements would necessarily be a breach of or cause an accommodation not to be reasonable to continue to occupy? So that seems to me to be the next point. Shall I repeat that because it didn't come out very well? We've dealt with the point that the two are not the same concept, and we've dealt with the point that suitability is not a lower standard than reasonable to continue to occupy. They're different, and suitability must be a higher standard than reasonable to continue to occupy, or we end up with that circularity, we end up with a revolving door. The next question is this decision in this case an unlawful decision because, notwithstanding that suitability is not the same as reasonable to continue to occupy and doesn't necessarily involve all the same factors, the reviewing officer failed to consider all the suitability requirements? And my submission in relation to that is, well, they're different, so no, it doesn't of itself, but there may be cases in which the suitability requirements are relevant, but that depends upon the submissions that are made on the review by the applicant. So we've seen what the representations were on review in this case, and in my submission they didn't raise, insofar as they raised overcrowding, or the fact that this is an unlicensed HMO, that was dealt with appropriately in the review decision.
Well, the reviewing officer thought that overcrowding was one of the issues.
He did.
Because he addressed it.
Absolutely.
He or she, yes.
He's a he. Unless you have any questions, those are my submissions in relation to ground 3.
Well, I have not quite understood your submission as to matters the local authority should think of for itself.
Right.
Because you accept that the fact of being an HMO and whether it was licensed or not is at least arguably a relevant consideration that you should think of for yourself.
So in my submission, the position is this. The representations on review set the agenda for what the reviewing officer has to consider, unless it was something that no reasonable authority properly directing itself would have failed to take into account. And that is why we say, or that is why the local authority was advised that the fact that this was, when it was obvious that this was an HMO, the question of whether or not it was an unlicensed HMO was something that no reasonable authority, was possibly something that no reasonable authority would have failed to investigate.
Yes. But one other question. Is Haruki still good law?
Haruki is still good law, yes.
Because from the brief look at it you showed us, it seemed to say, even if you're statutorily overcrowded, so it would not be suitable under section 209, I think it is, it can still be reasonable for you to occupy.
Absolutely. It's still good law.
And is that what it says?
That's what it says.
Well, in that case, why are we discussing overcrowding? If it's not if it doesn't automatically mean it's unreasonable.
So, what I could do, my lord, is take you to the Housing Act 96, section 210, which provides some things, and that's at page 43 in the authorities bundle, my lords, tab 4. And this is a clarificatory section to section 206. So you recall that section 206 says whenever you're providing housing to somebody in pursuance of a function or duty under Part 7, the accommodation must be suitable. And Section 210 provides some gloss on that. Section 210, subsection 1, which was in consideration in Haringey, says, in determining for the purpose of this part whether accommodation is suitable for a person, the local housing authority shall have regard to parts 9 and 10 of the Housing Act 1985, open brackets, slum clearance and overcrowding, close brackets, and parts 1 to 4 of the Housing Act 2004. That second section obviously was introduced in 2004, after the 2004 Act came into force. So the decision in Timor was dealing with a hazard under Part 1 of the 2004 Act, to which a local authority in determining suitability had to have had regard, but not, it was decided in Haringey, in relation to whether or not it was reasonable to continue to occupy accommodation. Sorry, in Timor, I apologise. And in Haringey, it was considering Part 10 of the Housing Act 1985, overcrowding. In fact, my lord, Section 210, suitability of accommodation, does not go so far as to say that if accommodation was overcrowded, it would be unsuitable. What it says is that a local authority must have regard to parts 9 and 10. And when you look at the suitability orders, you'll see that they're quite binary. They say it isn't suitable if you haven't been provided with a copy of the tenancy agreement, or if it's an HMO but it's unlicensed. This says you have to have regard to the overcrowding provisions. It doesn't say that if it is overcrowded, it is unsuitable. There is no similar provision to Section 210 in relation to reasonableness to continue to occupy. So there are provisions that explain circumstances in which accommodation would not be reasonable to continue to occupy. We have provided in the bundle at page 20, also tab 4, section 177, for example. You won't be surprised to learn that if a person is like a likely victim of domestic abuse in the accommodation that they are currently living in, that would not be reasonable for them to continue to occupy.
And there's power to specify by regulation other circumstances in section 1773.
Contrary to what we say in our skeleton argument, and much to my embarrassment, given that I was in BAPT, which dealt with them, yes, the
one you've given us,
yes.
1996.
Yes.
But is that the only?
That's the only one
that you're currently
so far
that you're aware of.
It's the only one, London.
What's quite interesting, at least it interests me, is that section 210 as originally drafted said shall have regard to parts 9, 10 and 11 of the Housing Act 1985.
Yes.
Section part 11
being the
bit that
HMOs.
went into part 2
yeah,
of the
HMOs.
2004 Act.
Yeah. But HMOs come within part 4 of the HMOs are included again because they're in the 2004 Act.
Exactly. So in the version you've given us in the bundle,
yes,
it refers to part 4 because that's where HMOs
have gone to.
But it reinforces the idea that there are two separate strands of statutory provisions, one for
yes.
HMOs and one for not.
Yes. So, my lords, unless there are any more questions on the submissions in relation to ground 3, my basic submission is that Timor is binding authority and it's hopeless. But for the same reasons set out in Haruki. Ground 1. So my learned friend referred to paragraph 65 and 66 of the skeleton argument produced by my learned friend and I, where we deal with the criminal liability that is imposed, and perhaps we weren't clear enough in the example we gave in paragraph 65 about the circumstances in which an individual occupier might be liable to an offence. Lord Stuart-Smith raised the circumstance in which 2 additional people moved into a house that was not yet overcrowded, and their moving into it caused it to be overcrowded, and could it possibly be intended that they were the people who would be guilty of an offence? And my understanding was that my learned friend was saying, yes, that would be right. Perhaps if I could refine that example, because if you look at the table of overcrowding...
It happens if you've got 2 rooms in a house and one of them's got 2 people in it, and 2 people move into the other room.
If you turn to page 7 in the authoritative bundle, the best example is the difference between 3 rooms... Sorry... If you have a house in which there are a series of rooms, and they're not overcrowded currently, or the whole house is not overcrowded, I apologise, and tenancies or licence agreements have been granted to individuals, not to couples, but the individuals each have living with them one other person. And then the last room is let out to an individual who has living with them one other person, and that causes the whole house to be overcrowded for the purposes of the table. My learned friend's position is that occupier who allows somebody to come and live with them is the person who is guilty of an offence, even though the room itself might not be overoccupied or overcrowded.
Looking at the numbers in table 1,
Yes.
the only time when the addition of 2 people tips it over is as between 1 and 2 rooms.
That's right. Yes.
So, as I said, the simplest example is you have a room with a house with 2 rooms.
Yes.
You've got a couple living in one room, and the other room is let to somebody.
Yes.
Who brings a second person in.
Yes.
The room's not overcrowded, but the whole house becomes overcrowded because you've now got 4 people in 2 rooms.
Absolutely.
Which exceeds
Yes.
the room standard.
Yes.
And I did understand that it was suggested by Mr. Van Heegen that second occupier would be guilty of an offence.
Yes.
Although he suggested it might not be appropriate to prosecute them.
Yes. And in my submission, that can't have been what was intended by the imposition of criminal liability in these circumstances if that room itself was not overcrowded.
Which it wouldn't be.
Which it wouldn't be.
If it was large enough.
If it was 110 square feet, yeah, or 9.54 square metres. So in my submission, the provisions relating to the criminal liability very strongly support the proposition that the separate dwelling for the purposes of the overcrowding legislation relate to the rooms over which the occupier has exclusive rights. And I say not of which they are the tenant because there might be circumstances in which they're a licensee, and the overcrowding provisions apply both to licensees and to tenants.
Well, it's a reason for not treating the whole house as a dwelling.
Absolutely.
Doesn't necessarily follow that the room is a dwelling, because then you run into the Eurotemp problem. Or you might do.
So, my lords, Eurotemp, the issue in Eurotemp was simply whether or not somebody who didn't share anything, so everything that's said about sharing is obiter dicta. The issue in Eurotemp was whether or not somebody who didn't share any part of their accommodation, but lived in their room and didn't have cooking facilities, whether or not that was capable of being a dwelling. And it was found that it was capable of being a dwelling. That's as far as it goes. And insofar as my learned friend relies on those set paragraph 58 of the judgment of Lord Millet, I think it is, that's insofar as he deals with sharing circumstances. That, of course, isn't relevant to the decision that they made, that their lordships made in the Eurotemp case.
But it was based on a lot of prior authority, which is reviewed and no disapproval is expressed.
Well, what is the issue is defined in paragraph 2 as if a room does not have cooking facilities in it, is it capable nonetheless of being a dwelling?
No, I think we understand that's the ratio.
So,
as my Lord said, we have Lord Millet in the House of Lords with the concurrence of 4 other of their lordships saying, if you share living accommodation with somebody else, it's not a separate dwelling. Are we to ignore that?
well,
do you dispute that as a proposition of law?
So, if I can deal with it in this way, the Rent Act cases were often about landlords trying to avoid granting what were going to be protected tenancies. So, Street and Mountford, but that's not really a sharing case or a residence case, because it was conceded that Mrs. Mountford and her partner had exclusive occupation of their room. But the long line of Rent Act authorities are about people trying to avoid the occupier being given Rent Act protected status.
Yes.
Eurotomp and Collins is a decision under the 1988 Act, section 1.1, and because Mr. Collins did not share any accommodation, it could not be considered under the Housing Act 1988 section 3. Because it wasn't a case where the effect of the things that he shared was to give him a dwelling, or all of the facilities that were necessary for a dwelling. So in my submission...
Understood, but we're dealing with a situation in which there's exclusive occupation of a room and then shared use of other facilities. And there are dicta in Eurotemp which address that situation. And my Lord's question is, what's your position on those dicta? You've told us that they're not part of the ratio, and we understand that submission. But nevertheless, is it your submission that they are wrong? If not, is it your submission that we simply ignore them? What is your position?
Right, so my position is this. What is the separate dwelling for the purposes of the 1985 Act, insofar as it relates to overcrowding, is to be determined by reference to the 1985 Act and not by reference to the 1988 Act or by reference to the 1977 Act. However, the 1988 Act or the 1977 Act can provide the factual basis that gives rise to the answer to the question of what is the separate dwelling for the purposes of the overcrowding legislation. So, the Rent Act 1977 section 22(1) says that if somebody shares accommodation but has exclusive possession of a part, that is to be deemed as their dwelling. That's to give them protection under the
Rent Act.
Rent Act. That is, the bit that they have control over is the bit that they have exclusive possession of. My own friend says, well, because they've used the word deemed, it therefore isn't the dwelling. It's deemed to be a dwelling. And in my submission, that's not an attractive submission. In effect,
the problem is this: the rent tax have always applied to property that's let as a separate dwelling.
yes.
There must have been, before what is now Section 22, back in the 1940s and before, decisions which said if you have got some accommodation which is exclusively yours and some which is shared, you don't have a separate dwelling because you're sharing your living accommodation with other people. And that follows as a matter of language. You can't say I've got a separate dwelling if part of your living accommodation is shared with somebody else.
That's absolutely right. And
there must have been a statutory intervention,
yes.
I think it may have been in 1949, which said we're going to reverse this by statute.
So,
in order to give people in that position protection.
my lord, I'm sorry to interject. I looked through the Rent Act 68 and the 57 Act, and I couldn't find an equivalent provision to Section 22 in either of those. So I'm not sure if it wasn't introduced in 1977.
Well, it may have been introduced in 1977. I thought it was older, but it doesn't matter.
No.
It's clearly introduced
Yes.
because of the problem that you don't get protection unless you've got a separate dwelling, and you don't have a separate dwelling if you're sharing your kitchen with somebody else.
Absolutely.
And that's all explained by Lord Millett.
Yes.
Well, but we're not dealing with a Rent Act protected tenancy. We're dealing with an assured tenancy. We're dealing with somebody with a room in a house of multiple occupation who also shares a kitchen with somebody else. They don't have a separate dwelling, do they?
They do, because we're dealing with an assured tenancy. Because Section 3 of the 88 Act has the same effect as Section 22 of the 1977 Act.
I'm slightly lost at that point. Can you elaborate on that submission?
Yes. So the 1977 Act, Section 22, is at tab 1 on page 3 of your authorities bundle. Tenant sharing accommodation with persons other than the landlord, subsection 1, where a tenant has exclusive occupation of any accommodation, open brackets, separate accommodation, close brackets, and A, the terms as between the tenant and his landlord on which he holds a separate accommodation include the use of other accommodation, open brackets, the shared accommodation, close brackets, in common with another person or other person not being or including the landlord, and by reason only of the circumstances mentioned in paragraph A above, the separate accommodation would not, apart from this section, be a dwelling house let on or subject to a protected or statutory tenancy. The separate accommodation shall be deemed to be a dwelling house let on a separate tenancy. So in effect, you get protected rent tax status if you have exclusive possession of a part of a house and you share accommodation with somebody else. Housing Act 1988, section 3, page 16. Oh, it appears to have been lifted mutatis mutandis. Where
there's no material difference, is there?
Well, except of course that it's a reference to an assured tenancy rather than protection under this Act. There's no difference.
Yeah.
So, forgive me, why have we got section 3 and section 22? Is section 3 the successor to section 22?
So what happened? The Rent Acts were repealed by the Thatcher government because it was suppressing the amount of private rented sector accommodation, and the 1988 Act was introduced, and so any tenancies that were Rent Act tenancies still existing when the 88 Act came into force remained Rent Act tenancies, but now the position in relation to private sector tenancies is and remains that there is an 88 Act tenant. It's a housing. It's what's called an assured tenancy.
Yeah. So it's a limited form of protection. It's a lesser form of protection than under the Rent Acts.
Well, a full assured tenancy is probably subject.
Yeah.
There's no rent. There's no rent regulation.
Yeah. Yeah.
But otherwise, it's the same. There is a form of tenancy called an assured short hold tenancy, but they're the ones that are are causing lots of angst at the moment because the landlord can obtain possession just by serving a valid Section 21 notice.
And the government's proposing to repeal Section 21.
Yes. Now, the 1985 Act also introduced a new form of tenancy. Well, it didn't, sorry. It was a consolidating act, but it gave rise to something called secure tenancies. Part 3 of the 85 Act provides for tenancies that are let by public sector bodies. They have no equivalent tenant sharing provision. So if you look at the case of Parkin and Westminster City Council, which appears in your bundle, Parkins, I apologise, at tab 12, that was a case in which Mr. Parkins shared a house with another teacher, and the issue was whether or not he had a secure tenancy under Section 79 of the Housing Act 1988, and he could not rely on a similar provision to Section 22 of the 77 Act or Section 3 of the 88 Act.
So this is all very interesting, and thank you for your helpful explanations, but why does this not tend to confirm that the purposes of Section 22 of the 1977 Act, Section 3 of the 1988 Act, and the various other provisions you've just been discussing are all rather different? And what we should be concerned with in the present case is interpreting the definition in the 1985 Act in the context of that Act and having regard to the purposes of that Act.
My Lord, yeah. So, in my submission, the point is this. Under the 77 Act and under the 88 Act, the occupier's dwelling is the bit of which they have exclusive possession. And that informs what you determine is their dwelling for the purposes of the overcrowding legislation.
But why so? Why? Because they're different statutes enacted for different purposes.
Because that is the...
I mean, it doesn't necessarily mean that you're wrong on your interpretation of the 1985 Act. That's a separate question. But what we're querying at the moment is whether you're really assisted by looking at, in particular, the 1977 Act, which is the one that came before. I mean, life gets more difficult when you get to the 1988 Act for the other reason that we touched on this morning. But fundamentally, these are different statutory provisions for different purposes.
So, my Lord, I agree with you. But what the 85 Act does in Part 10 is create criminal liability for the occupier in relation to the dwelling, which must be the same dwelling that is defined in sections 325 and 326. And it is inconceivable that criminal liability was being created in relation to something over which they had no control.
But that's a point you can make independently of take the paradigm example, the 1977 Act, Section 22.
It is, because it also applies to licences as well. So I accept that. It's my submission. It just provides support for the argument.
All right, where do you want to go next?
Sorry, can I just grab my notebook off of this? I could move on to ground 2, my lords. And
Well, I think it would be helpful to us if you could just summarise your submission as to the correct interpretation of the definition section
yeah,
in the 1985 Act. Because at the end of the day, for purposes of ground 1, that is central. So it's section 343 and the definition of dwelling.
so, my lords, in my submission, for the purposes of the definition of dwelling, section 343 of the 1985 Act, the dwelling for these purposes is the accommodation that is used as a separate dwelling. And what Mrs. Rowe had as a separate dwelling in this case was her bedroom. If and insofar as it is suggested, well, she also had access to the kitchen, therefore that wasn't her separate dwelling, the overcrowding provisions require you to have regard to sleeping rooms. And in both sections, sections 325 and 326, a sleeping room is defined as a room is available as a sleeping room if it's a type normally used in the locality either as a bedroom or as a living room. There was no suggestion in this case that there was any shared living room.
What do you say to Mr. Van Heegen's submission about the use of the words "or suitable for use" as a separate dwelling? Because that is the basis for his submission. He accepted he gets nowhere if one concentrates
so
on
in my
use.
submission, if the premise, I apologise,
So he relies on suitable for use.
Yep. So in my submission, if the premises are actually being used as a separate dwelling, the alternative provision or suitable for use doesn't arise. Because Part 10 is dealing with overcrowding. And therefore you must be looking at a factual position on the ground. Once accommodation is suitable for being used for use as a separate dwelling, I apologise. If the accommodation is not occupied, then the overcrowding regulation rules are not going to arise in any event.
So why include the words "or suitable for use" at all? On that submission, they're completely redundant and pointless.
Well, I would say they arise in circumstances in which the premises would not in fact be described as a dwelling, but come within the Euratom provision that says, well, it can be your dwelling if you don't have a kitchen in it. So it doesn't necessarily have all of the facilities, but it is suitable for use as a dwelling.
I'm not sure where that comes from.
No. Well, no, I have real difficulty understanding what the purposes of the words "or suitable for use as a separate dwelling" are in circumstances in which what is being dealt with is a factual position on the ground of overcrowding. You could, if the premises were suitable for use as a dwelling, but there was nobody living in them, how are you going to assess whether they're overcrowded or not?
You're not, but you might still commit an offence if you're an intending occupier you can be an intending occupier of a dwelling even if you haven't occupied it, and even if it's empty. Look at section 331.
Or a landlord intending to let.
Yeah.
Yeah.
The intending occupier of a dwelling may apply to local housing authority for a licence. Now, if dwelling only applies to properties that have been let, you can't have an intending occupier of an empty dwelling because it's not a dwelling. So in those circumstances, dwelling must mean not something that is occupied, but something that's suitable to be occupied.
My lord, yes.
And similarly, when you look at the landlord's offence, fails to make inquiries of the proposed occupier, of the persons who would be allowed to sleep in the dwelling, you've clearly got to have a dwelling before you start having proposed occupiers of it.
My lord, yes. My lord, it's my submission that in this case, the case put by the other side that you should have had regard to the whole house in determining whether to decide that met the definition of dwelling for the purposes of Part 10 of the 85 Act is simply wrong. It's nonsense.
You don't need to go further than that, do you?
No.
You don't need to establish, for your purposes, that the separate bedroom is a dwelling for section 3.2, whatever it is, purposes.
No.
One of the reasons why my lords asked for the statutory history to be looked at is that when you look at the overcrowding provisions in the 1957 legislation, the predecessor of what's Part 10 comes first, and then it's followed by what was then Section 90, which, as my lord said, you can follow through into subsequent things, which deals with overcrowding in properties that I think we would now call HMOs. They weren't called HMOs then. So properties let as lodgings, or in which there's more than one family.
So my lord, if you turn to tab 3 in the bundle that I handed up just after lunch, Section 67 comes from Part 4 of the Housing Act 2004 dealing with HMOs. And you'll see subsection 3 of Section 67 says, a licence must include the conditions required by Schedule 4. Schedule 4
requires you not to have it overcrowded.
Absolutely. So there is separate provision for overcrowding of HMOs to be provided in the licence.
My point is, there always was separate provision in Section 90 in the 1957 legislation. There was separate provision in the Housing Act 1985 in Part 11.
Yes.
It's now been hived off to the 2004 Act. But
my lord, I was just indicating that it's still there.
It's still there. Which tends to suggest that well, there isn't a gap if you can't use Part 10 for HMOs.
No.
Because you use licence conditions now, and you previously used Section 90, where the local authority served a notice on an HMOs.
My lord, yes.
So you don't actually need the submission that the room is a dwelling. All you need is a submission that the house is not a dwelling.
My lord, yes.
Doesn't it, there's a more extreme position to be taken, which is that sections 324 to 326 don't apply to HMOs, because what deals with HMOs is the line of statutory authority that goes straight through to Part 2 of the 2004 Act.
My lord, My submission would be that the overcrowding legislation does apply to HMOs because there may be, as this was, it's an unlicensed HMO. And the difficulty is that the local authorities cannot close unlicensed HMOs. So you can't make an order closing them. And if a HMO is an unlicensed HMO, the landlord cannot obtain possession of it. If the premises, he can't serve Section 21 notices in relation to unlicensed HMOs, premises and unlicensed HMOs. So in effect, that status quo is maintained.
I mean, there's clearly a fairly substantial change in the regime by the introduction of the 2004 Act.
There is.
And it's specific to HMOs.
It is. But
can you just explain to me again once, because I didn't get it down and I'm definitely not going to remember it, why you say that despite the two strands of legislative provision, one apparently dealing with a dwelling house as it was originally,
yes,
and the other dealing with houses in multiple occupation coming through. Why? I mean, certainly when you look at the 1957 Act, I haven't looked at the earlier acts, it immediately stands out that you've got the provisions dealing with dwelling houses, and then you've got the provision dealing with HMOs. Right. And you follow it through in the way that we indicated this morning.
Yep. So my lord, if you go back to paragraph 1A, which is
in the 2004 Act.
In the 2004 Act,
yes,
you will see that that wasn't introduced until 2018.
What happened to what had been Section 358 of the Housing Act 1985?
It was abolished. I mean, it was repealed.
Yeah, but in 2004, where did that end up?
Well, so my submission is that initially there wasn't provision in relation. It was hoped, I think, that the licensing would deal with it. There wasn't an equivalent provision in relation to overcrowding in lodgings.
What you get is Part 2.
Yes.
It may be the law of unintended consequences. But surely, if one was right to read the previous statutes as
having
one section dealing with dwelling houses, or dwellings as they became, and one dealing with houses let in lodgings which became houses in multiple occupation, if you would at the time have read those as saying, we've got a house in multiple occupation, we better look at section 90 or whatever it was.
My lord, yes.
We don't worry about the others. How can the meaning of it change simply because they changed the regime for HMOs?
My lord, if you take the language of HMOs of Part 10, there's no provision to say these standards do not apply to lodging houses.
True.
But why was Section 90 ever enacted then?
Because when they were originally enforced, wasn't it about housing for the working classes and lodging houses in respect of which there was a distinction?
What do you think? Lodging houses might not have been for the working classes?
Yes.
Seems a rather unlikely scenario.
I mean, Section 90 under the 57 Act, and I think you've helpfully found it where it comes from before. You would have to say this is additional protection for people in lodgings.
My lord, yes.
And that if the rest of what precedes 90 in the 57 Act, which is includes 77 is overall protection. But if it appears to a local authority in the case of what we would now call an HMO, that it's overcrowded or whatever it is, then they can serve a notice. And this is separate and additional protection.
My lord, yes.
Is that the submission?
That's my submission, my lord, yes.
I wasn't sure I heard it put in quite those terms before.
No, I probably wasn't that lucid, my lord.
But otherwise one goes down, if they're separate and different.
So, my lord, the section 90, subsection 1 gives much more discretion to, it doesn't provide a prescriptive algorithm or equation for determining what
They didn't have algorithms in 1957.
I'm sorry. It doesn't provide an equation for determining what is a how overcrowding is to be measured. So it's left in the discretion of the local authority. And in my submission, there's nothing to say that the section 78, sorry, section 77, section 77 and schedule 6 table don't also apply to lodging houses. So a lodging house might be regarded by a local authority to be overcrowded, notwithstanding that it doesn't is not overcrowded under that equation. I mean, if it had been expected,
there must be authority on this, or there must be some writing on this when these provisions sat side by side.
My lord, yes.
Speaking entirely for myself, I would feel more comfortable if I had some contemporaneous or authoritative exposition of how these fit together.
My lord, yes.
Don't know about anybody else. Okay, anyway, that's your submission.
That's my submission on ground 1. In relation to ground 2, insofar as it relies on ground 1, I repeat my earlier submissions. Insofar as it is said, well, you should have had regard to some other measure of overcrowding. In my submission, that would have required Mrs. Rowe to have raised something in her representations on the review, and everything that was raised in her representations on the review was dealt with in the review decision.
And it can't be suggested that to the extent that, I'm sorry to keep interrupting, to the extent that it's suggested that the attitude of the neighbour who doesn't like her children in the kitchen or making a noise, to the extent that that raises an issue of overcrowding at all, it can't be said that their response is irrational.
Absolutely.
Okay. I'm sorry to dot the I's and cross the T's.
What if a judge, what Mr. Van Heegen relied on was 27E and F of his skeleton. Failed to take into account the number of people sharing bathroom and kitchen facilities, and failed to consider overcrowding in the context of the needs of the appellant's children for space and privacy.
So she doesn't say there's a queue outside the bathroom or outside the kitchen.
No.
We see the property is occupied by 4 other people. So if it had been, she's made an application to the local authority made a decision, she's raised complaints, but she doesn't say, I don't get to bathe my children, we don't get to the bathroom, and she doesn't say, I don't get into the kitchen.
She does say one of the other tenants complains about her children running around the kitchen.
On one occasion.
Yeah. Well, there may or may not be one occasion. Yeah. That may be yes.
But they're both dealt with.
How did the judge deal with this? Well, were these points taken before the judge?
They were.
And how did the judge deal with it?
He said that they were... Excuse me, my lord. So perhaps it's paragraph 93 on page 60.
No, I think
Well, no, because this is all about failure to make inquiries. So I don't think that can be the relevant paragraph, can it?
I think it's 76. It was considered separately.
Yes.
Leaving aside statutory overcrowding, the reviewing officer considered it separately.
Yeah, because the argument that was being put, which is quoted at 67,
Yes.
is that it was argued that the review decision treated the statutory definition as conclusive. In other words, didn't consider the matter separately from that. And the judge's finding is, yes, it was considered separately.
Well, my Lord Justice Arnold suggested that the failure was a failure to make inquiries, and that was the
No. I was saying that was ground 7 below, which is later.
Yep.
But this issue, as my lord points out, is addressed by the judge at 76,
Yes,
responding to the argument he records at 67.
my Lord, yes. But for the purposes of these second appeals on Section 204 appeals, what you need to consider is the review decision rather than the judge's decision. So is the review decision lawful? Not the basis on which the judge found that it was lawful. Of course, the review decision, as I said on a number of occasions, the reviewer is primarily concerned with the representations that the applicant makes on the review.
Yeah.
And those matters that Mr. Van Hagen raises are not ones that were argued or put with any, well, at all. And indeed, the respondent did consider the appellant's children's need for space and anxiety.
That's paragraph 12.
He didn't consider the number of people sharing the bathroom and kitchen facilities within the property because it wasn't suggested that those were causing Mrs. Rowe a problem.
As a general proposition of law, would you dissent from the proposition that statutory overcrowding is not the only relevant consideration?
No.
You wouldn't sanction, or you would sanction and it isn't?
No, I wouldn't. It is not, sorry, statutory overcrowding is not the only relevant consideration. I agree.
But you say the relevant considerations are those that are raised on the review,
Absolutely.
in the representations, or those which are so obvious that any local authority should have regard to them.
Absolutely.
And you say this doesn't fit into either category.
No more.
Well, I think it's very clear what your position is. Thank you.
Can we return to the point that my Lord Justice Stuart-Smith was raising with you earlier? And I appreciate you've already indicated you don't know the answer to this question, but I just want to explore it a little further. As you've gathered, the court is interested in the legislative history, and I think it's most conveniently taken from the 1957 Act, which is the interrelationship between the different provisions. So the overcrowding provisions, particularly 77, 78, on the one hand, and then the seemingly separate provision in section 90 on the other hand. And the question was raised as to whether there is any source of illumination to be obtained. Now, there's two possible sources. First of all, is there any authority? And presumably, if there was, you would have turned that up in the researches already. But even if there's no authority, was there ever any commentary on that? Now, if you think it's a waste of time even looking, then do by all means tell us. But if it would be worth a quick search, we would be grateful to see if there is anything that would shed any light on that question.
So, my lord, we got the relevant statutory provisions going back to the 1935 Act. I didn't look for any authorities, so the proposition that if there were any, we'd have turned them up is wrong. I confess we didn't look for them.
All right.
The 1985 Act was a consolidating act and consolidated the 1980 Act. And, it may very well be that there is there was some sort of preparation of parliamentary report or something like that.
We've got the Law Commission report. That's what it does. Is the Law Commission report was the basis for the consolidation.
Yep. It was, but it's very late. The acts themselves are 1985, and the Law Commission report is 1985. So
it's a consolidation exercise, and what the Law Commission does is it looks at whether the existing legislation that is to be consolidated, whether it recommends any changes.
Absolutely.
And it recommended deleting the working classes provision.
Yes.
There's a whole series of recommendations set out at the beginning of the report.
That's right, but the 1985 Act also, for example, introduced the right to buy. Well, it consolidated from the 1980 Act.
Yes. I don't think it introduces wholly new policy questions.
No.
You don't use consolidated. There's a consolidation procedure in Parliament,
yeah.
and it has to be certified that there are only minor amendments.
So perhaps the sensible place to look is in the 1980 in relation to the 1980 Act.
I don't know if there's any textbook commentary on the pre-1985 position under the Housing Acts, whether there was an equivalent to what is now the Encyclopedia of Housing Law.
The Encyclopedia of Housing Law is pretty encyclopedic, so it may very well be that Andrew Arden and the other authors of that have considered the position. But I'd be very happy to carry out some researches. I recognise, I can see the issue that arises if there were meant to be two regimes, one governing premises that were let as a dwelling separately, although it doesn't say let as a dwelling.
I think the submissions and the sort of archaeology that we've done already raises the question which we're going to have to say something about.
My lord, yes.
So I think we need comfort.
So in other words, if you are able to provide any further assistance, either by way of authority or by way of commentary, we would be very grateful.
My lord, yes. What I would propose to do is, if I unearth anything, to obviously share it with my learned friend.
Of course.
And then we either just present it on its face with no written submissions, or try and agree something.
That would be very helpful. I mean, we're not calling for further argument.
No.
Simply any further materials that might shed further light on the arguments we've already heard.
My lord, yes.
Thank you so much. Mr. Manheath.
Yes, Lords, if I could just reply to those three grounds. In relation to ground 3, I'm concerned it's rather become more complicated than it is. All we're saying in relation to ground 3 is that it's wrong to exclude from the reasonableness consideration suitability requirements. And I don't understand my learned friend to be seriously disputing that. He doesn't seem to dispute that the reasonableness test is as I set it out from the code, that it's taking account of all relevant matters. and that certain suitability considerations can be relevant to reasonableness because they will be, in some cases, relevant matters. And he doesn't seem to dispute the fact that, obviously, certain things which are relevant to suitability, the respondents now accept are relevant to reasonableness, which is why they're going back to do the review again. And our argument is not, as I said in my submissions, the Timor argument that the authority has to go off and do a suitability assessment. We don't say that, that's not our argument. Our argument is a very simple one, is that if you've got information which may be relevant to suitability, you don't exclude that when considering reasonableness.
Yeah, but what divides the parties still is whether it is sufficient for the council to do that which they have said is going to be done when the review is repeated, namely to take such further inquiries as may be reasonable, having regard to the information that the property is an unlicensed HMO. That's as far as the council goes. They've accepted they're going to do that. They've not accepted anything further. So the question is, do you say that there is something more that they need to take into account as a relevant factor that they haven't done so or agreed to do?
Well, it's the implications of that, and I think my lone friend said they would have to go and do an inspection to see how many rooms there are and how many people there are and the nature of the kitchen and so on. So,
Sorry, I didn't say how many rooms there are around.
I think he was saying that there was going to be an inspection because that's
No, he didn't commit himself to an inspection. He said it might well require an inspection. So it's not a commitment, it's an acknowledgement of the likely realities of the situation.
In my submission, that rather supports our argument that things were not taken into account in relation to the review decision, which the respondents acknowledge now should have been taken into account, and they will take.
But the only thing that hasn't been fully and properly taken into account to date is the fact that it's an unlicensed HMO. That's the extent of the concession.
Yes.
And then the question is, and I appreciate you make the point, and I get this. You say, well, that has consequences.
Yeah.
Because as soon as you acknowledge that A, it's an unlicensed HMO, and B, you haven't fully considered that, then you've got to go back, redo the review, and properly address the implications of that. And I fully understand, and I'm not trying to minimise that. That could be quite significant. The question is whether you're trying to push for something else to be taken into account, other than that.
Well, yes, in relation to that, but can I just say the consequences of it being an unlicensed HMO raises the question of, in order to get a licence, would it be able to get a licence or not? And if it wouldn't be able to get a licence, why wouldn't it be able to get a licence?
Absolutely, this is why it's a potentially significant inquiry, to be sure.
We also say, I'm going to come to this point now, we also say that there are other issues in relation to overcrowding, which I'm going to come back to in a moment. So that deals with ground 3.
But before you leave me, I had understood you to be maintaining paragraph 35 of your skeleton argument. Which is that the review should have considered not only that it was unlicensed, but the fact you didn't have a written agreement, and the fact that it was unsuitable for a family within the terms of the 2003 order, and the position of the children.
Yes, we do maintain that.
So that remains your case.
Yes.
Okay.
A and B were not really.
Sorry?
A and B were not pushing.
Well, you've got A.
Well, no, it's the ipso facto point is what you're not pushing, as I understand it.
Yes.
You say that these are not excluded from reasonableness, on the contrary, as we've just discussed, so far as unlicensed HMO is concerned, it's common ground, that is something that has to be considered.
Can I ask you one more question before you leave grounds tree? One of the points Mr. Grundy made was that you, as he understood it, was submitting that suitability was a lower standard, easier to meet than reasonableness, and his submission is the other way around, that suitability is a higher standard than reasonableness, so that something can be reasonable but not suitable. Do you want to say anything about that?
Yeah, well, two things. Firstly, this is one of the things that I think has clouded the simplicity of ground 3, because it doesn't really matter.
Right.
The fact is they're related, and whether one's higher than the other doesn't matter. But we do say that, yes, suitability is a lower standard, because, of course, as we've already canvassed this morning, one only gets suitability once it's been established that the applicant's homeless.
Yes.
In order to establish the applicant's homeless, there has to be an accommodation that's not reasonable to continue to occupy. But that accommodation may nevertheless be suitable. So they've overcome the reasonableness hurdle, but the accommodation's not so bad that it's unsuitable.
And that's the alley point.
Yeah, exactly. So in relation to ground 1, we would also like to take the opportunity to look at the relationship between these two strands which seem to run through the legislation. But what my learned friend seems to be saying about this is that they're not exclusive, and that the lodgings come HMO strand is really an additional form of protection in relation to overcrowding. And we wouldn't dissent from that proposition. And of course that means that one doesn't have to ignore Part 10 of the 85 Act. It's still relevant. And then the HMO is a sort of bolt-on additional. And we repeat the point that primarily one's looking at the definition in, I think it's section 343, and construing that definition in the light of Euro 10. And that neither the room nor the shared house were being used as a separate dwelling because of the sharing. But that if the room could be used as a separate dwelling, that doesn't preclude the fact that the shared house as a whole could be used as a separate dwelling. And so it may be that one's got two things to look at, the room and the house, but the point is, nevertheless, one's still got to look at the house. So the room being a separate dwelling, if it is, and we say primarily it isn't, but if it is, it doesn't preclude our argument that the shared house as a whole is a separate dwelling. And then in relation to ground 2, of course, if it does transpire that these are two completely separate regimes, and that the shared house has to be considered in the context of the HMO regulation, then that is something which, of course, the respondents haven't done, because they've only considered it as possibly overcrowded under Part 10 of the 85 Act. They haven't considered it as an HMO under the 2004 Act. So if that's a completely separate regime, but even if it's a bolt-on, as my learned friend says it is, then they have erred in law by not considering the fact that even if the room is the thing to be considered purely as statutorily overcrowded, one's still got to consider the fact that the room is situated in the HMO, which is subject to a whole load of other standards and conditions. And in relation to the complaint was made on one occasion, but obviously the interaction between the children and the tenant was on multiple occasions. So it's the complaint that was one thing, not the tenant irritating the children. And those are my submissions in response, if I can, unless I will be of any further assistance. But if we could have, we probably need about 2 weeks, or, I mean, I'm in my Lord's hands, but...
Well, obviously, the more quickly you can do it, the better. But I appreciate that you'll have other professional commitments, particularly at this time of year, and I'm not going to set any deadline. But if you could, I think what I'm going to do is invite Mr. Grundy and his team to go first with the research and to provide you with the results of their research as soon as they're able to. And then you can see if you think there's anything missing.
Yes.
All right. Thank you all for your submissions on this interesting and difficult area of the law, for which we are very grateful. Given the difficulty of the issues and the importance of them, we will obviously be reserving our judgments, and we will be grateful for any further assistance that you're able to provide us with in writing, as we've already discussed. If you come up with a blank, don't worry, we will do the best we can with the materials we can. We just would like to know if there is anything further that would assist.
My lord, I'm sorry to interject. It might be sensible to provide a guillotine, because otherwise you might be waiting for us to send in something.
All right, yes, I will set 14 days from today as a long stop, but encourage you to do it more quickly.
My lord, thank you.
Once we have written our judgments, they will be circulated in the usual way, that is to say, they will be issued to council as a draft before hand down, under embargo, and I hope everybody in court now understands the seriousness of the embargo. It is to be strictly adhered to. And that is for the purposes of correcting typographical errors and obvious glaring factual mistakes, not for the purposes of re-arguing the case, and also to enable, if you possibly can, to agree a consequential order that we can make at the same time as handing down our judgment. If you are unable to agree the consequential order, please put in short written submissions on the points that divide you.